Yep. All right, good afternoon, everybody. Welcome to today's lecture. We're honored to host Professor Justin Simard from Michigan State. His work is really interesting, groundbreaking, and it really compels us to confront the enduring legacy of slavery within the American legal system. Professor Simard is a legal historian and an assistant professor at MSU. He teaches professional responsibility, legal history, commercial law. He holds a JD and a PhD in history from Penn, as well as a BA from Rice University. His scholarship focuses on the intersection of law, lawyers, and economic development in 19th century America particularly, and examines how the legal profession legitimized slavery through commercial practice. As the founder of the Citing Slavery Project, Professor Simard has led a team in uncovering thousands of cases, at least 14,000? At least 14,000. In cases involving enslaved people, revealing that many of these cases continue to be cited in modern jurisprudence. His research highlights how American lawyers and judges have historically obscured their role in slavery by failing to fully acknowledge it, and how this legacy persists in today's legal citations. So he will be discussing the implications of the ongoing reliance on slave-era legal precedents and the necessity of the legal profession to confront its historical complicity in slavery. His work, again, challenges us to reflect on the foundations of our legal system and consider the steps needed to address these enduring injustices. So please join me in welcoming Professor Justin Simard.
All right, well, thank you for the introduction. I'm really excited to be here to share my work with you, and I should mention that this work and everything that I'm presenting here is a product not just of my own work, but also of the work of, at this point, probably 30 or 40 students who've worked with me over the course of the project, so just keep that in mind. As the introduction mentioned, law was critical to the establishment and growth of American slavery. So, although American courts authored thousands of appellate opinions on this subject, however, the influence of these cases remains underappreciated today. And so today I'm going to talk to you about how the law of slavery is constructed, why legalistic reasoning and legal research tools have combined to lead American lawyers to continue to rely on these cases and the principles derived from them, and why it's important for us as a legal profession to address slavery's legacy that continues today. I'll also tell you about the Citing Slavery Project. As I mentioned early on, I realized that scholarship alone was not going to address the extent to which the American law was built on slavery and has been influenced by it. And so in addition to continuing to do this research, I presented part of that research earlier at the faculty workshop. I'm also working with students, both undergraduates and law students at Michigan State and a couple other schools actually, to build this database of legal cases, which is available at citingslavery.org. So today I'm going to first begin by introducing the most obvious manifestation of slavery's legacy, the citation of a case involving an enslaved person by a modern court. And then I'll move on to discuss how the law of slavery was built originally in the 19th century, then to how those cases are being used both directly through citation, but also indirectly through doctrinal development. And finally, I'll conclude by talking about what my students and I are doing to try to address this legacy of slavery. So from commerce to criminal law to the law of trust and estates, American appellate courts authored more than 14,000 cases by our count involving enslaved people. Now, we're not totally finalized on the count. We're still finishing initial collection and doing some verification, but I'm pretty confident that this number is going to stand. And despite their prevalence, however, they've received little attention from legal scholars. I think that's because, like judges, most legal scholars say that these cases are just normal cases. So it's not a case in the law of slavery, it's a case about contracts. And law professors Will Bode and Stephen Sachs, for example, argue that because the legal system treated people like ordinary property, these cases just state ordinary rules of law. I think this is an oversimplification, and let me give you one example why. So this is a case, 1999, the Tennessee Supreme Court faced a pretty simple issue. could you reward damages both for loss of use and decrease in market value? So what happened is the shredding machine got on fire, and when it was being used, it was being rented out, and the question was what damages were available. And in coming to its decision, the court cited Johnson v. Perry, which is an 1841 case from Tennessee Supreme Court. Now, the court cited this case because it was the first opinion to explain what damages were available for injuries to personal property. And I'll read it to you now. Keep in mind that these are the words not of a judge writing in the 19th century, but in 1999. The court held that the injury had been temporary. The plaintiff could recover damages for the loss of the slave's service. If, however, the slave had been permanently injured, the plaintiff could recover damages to the deteriorated value of the slave in lieu of damages for loss of service. Finally, if he had been killed, the plaintiff would have been entitled to damages equal to the actual value of the slave, but would not have been entitled to recover damages for loss of the slave's service. So here, this modern court is treating this case about a person just like it's a regular tort case, right? Very matter-of-factly. Johnson v. Perry, however, it didn't involve a regular piece of property. It involved a man named David who was enslaved in Tennessee. And basically what happened was David got into some kind of altercation with a group of white men, and they wanted to chase him down to chastise him. And as you can imagine, that he was very afraid of what would happen if they caught him, so he was running away from this group of men and jumped into a creek, about 4-foot tall ledge, and severely and permanently injured his leg. And although the court blamed David for his own injuries, they compared him to a frightened animal. They ultimately rewarded damages to his owner who brought the suit. Now, this kind of callousness to David as a piece of property was a natural result of slave commerce. So in that twisted system, it kind of made sense. But the decision to cite a case involving an enslaved person like David more than 150 years after abolition, I think, requires more analysis and thought. We're not in that same system. Why do these citations matter? Well, citations give judicial opinions, as another scholar has written, the aura of authority, and they allow judges to harness the authority of the past. As Frank Cross has argued, citation to a case, even if that citation is a string citation, provides information about the continued relevance for that case for legal disputes coming before this court. From this perspective, all citations provide meaningful information about the law. They show that slave cases have helped judges not only justify their decisions, but also constitute their authority, right? That's part of the role that these cases are playing. Now, the first step to grappling with this legacy is to understand the context of where cases like Johnson v. Perry arose. It's important to recognize that slavery was an enormous economic institution. Historians of capitalism have noted how enslaved people were the largest category of personal property in the United States. Their market value actually constituted 20% of all wealth in the United States. And slavery had an economic impact not just in the South, but across the U.S. as well. And the market value of enslaved people was not the only reason they were legally and economically significant. It was also that in most jurisdictions they were classified as personal property. And before the 18th and early 19th century, the only property that really mattered was land, real property, right? But they're one of the first, they're treated as personal property in an area where we're still trying to figure out the rules of personal property. And one of the reasons they continue to be cited is because this is where the courts figured out these rules in an area where there's really, the property was extremely valuable. Now, as a result of this economic influence, you might imagine there's lots of legal disputes. And what lawyers did in these legal disputes is they used their legal expertise to fit these cases into long-standing legal categories that they shared with lawyers across the United States. So a case about the sale of an enslaved person fit into the category of law of principal and agent, just like lots of other cases, right? The case of the seizure of an enslaved person was a matter of the law of debt. And the case of borrowing enslaved people became an issue of conversion of property. So they used the same legal categories that Northern lawyers used. And these are just a few examples, but this happened thousands of times with everything from fraudulent conveyances and technical rules of trust and estates to levies, mortgages, and share sales. Even Ohio had a few of these 14,000 cases, not many, but Here's a list. Price v. Slaughter involved an attempt by a formerly enslaved person to recover property. And says it raised the question of whether children of enslaved people could be legitimate heirs, even though marriage between enslaved people was illegal. Milliken was a case about interpreting the Ohio Constitution, which said that only white people are allowed to vote in Ohio, so who counts as white? Anderson was a case related to the purchase of an enslaved person's freedom. And the Tom v. Daly case, the court dealt with the question of will a court of equity permit someone to claim, basically by his declarations and promises, this is a really horrible case. This person was able, he wanted to purchase his sister at less than half value, and then he was able to tell other people, please don't bid higher, I'm going to purchase my sister. And then he sold her and claimed her as a slave. So those are just examples of, even here in Ohio, slavery was not outside of slavery's reach. Involvement in slave commerce meant not only ruling on cases involving enslaved people, but actually actively involving, courts were actively involved in slave commerce. So these are all ads put for sheriff sales that took place on the courthouse steps. So in fact, South Carolina's judicial system dealt with so many cases related to slavery that it was the largest auctioneering firm of enslaved people in the entire state, right? So this is something that's happening. Courts are actively involved in the sale of people. What were the effects of these actions? Well, you can imagine that translating slave commerce into common law supported the slave system. So resolving basic questions of inheritance helped people pass on the people they owned to their heirs. Mortgaging enslaved people allowed slaveholders to capitalize on their human assets. Regulating the practices of hiring out enslaved people stabilized an active market in the rental of human beings. And all of these practices exposed the enslaved to the horrors of slavery. The enforcement of wills led to family separation and sale. So did the secured transactions, right? When people were seized, they weren't all seized. Sometimes part of families were seized. Courts generally didn't consider the perspective of enslaved people when they made these decisions, right? So they were okay with essentially allowing the slave system to operate as it did. Now, if you think there's ever a time when we're going to move past this system, it'd be during the Civil War and after the Civil War during Reconstruction, right? 600,000 soldiers are killed fighting over the legacy of slavery, so you think now is the time to reckon with this legacy. But the problem was this reckoning was incomplete. American lawyers continue to treat agreements about enslaved people as regular cases. So Osborne v. Nicholson is a great example of this in the Supreme Court. The question was, essentially someone had purchased an enslaved person using an installment plan. And the question was, okay, now that an enslaved person has been emancipated, do I still need to pay these installments? Now you might say, well, who cares whether you do or not? Both those guys are terrible. The guy selling this person and the guy buying this person. But the court could have thought more creatively, right? They could have said, let's find Albert, the man who is subject to this transaction, and let's make you pay him. And instead of paying the person who you bought him from, pay him himself, right? And this would be a way of some form of reparations. But this was beyond what the court would consider. So as a result, the world of slave commerce had been uprooted, but its legal legacy remained. And legal research tools actually help solidify this legacy. So when in the same time period that Justice Swain decided Osborne v. Nicholson, John B. West, the founder of the West reporting system, was starting his reporting. And what he did is he classified these cases involving enslaved people in the same standard legal categories that Northern lawyers used, right? And so this system was inherently conservative, right? Because it was designed to fit cases into these pre-existing categories. And this treatment, therefore, solidified the positioning of slave cases as normal law. Because these cases have been categorized in these standard legal categories, they've continued to influence American law. And they do so both directly by being cited as precedent and also indirectly by shaping doctrine. So let me start by the direct citation of these cases. My original research uncovered roughly 350 direct citations by modern American judges to these cases in the last 35 years. So here's all the states where I found that. You'll notice it's not just in the South, it's also in northern states like California and here in Ohio. Here's the result, thanks to the diligent work of my team, of all the states that have cited a slave case in the last 35 years. So everyone but Nebraska has cited one of these cases that we found. And now, to be fair, most of these cases don't look like tire shredders, and not all rely on cases that treat enslaved people as property. However, judges in many of these cases cite them for basic propositions of law in regular subject matter areas. And what's especially troubling is that in roughly 80% of the cases we found, the court does not acknowledge a case's slave context when it cites to that case. So, say what you will about the tire shredders court, but at least they acknowledged this case. They weren't trying to hide the fact this case involved enslaved property. But most lawyers do, and whether that's deliberate or accidental, we can talk about. And I think that analysis of these cases without acknowledgement causes two major harms. The first we'll classify in the legal realm, right? So analysis of these cases without acknowledgement creates the risk that judges and lawyers might rely on cases in which this malleable boundary between person and property creates confusing precedent. So even though enslavers in the 19th century were very committed to the institution, they also recognized this was that enslaved people were not normal property, right? That there are times where you wouldn't hire out another kind of property, right? In that same way. So what that means is that slave precedent may therefore provide less clear authority than a court's initial reading of a case suggests. So in tire shredders, for example, the court actually ultimately distinguishes Johnson v. Perry because they say, we're dealing with commercial property that's difficult to replace, and therefore this earlier law doesn't apply here. But if you know anything about the context of 19th century slavery, enslaved people were considered commercial property that was difficult to replace. Like, what is more difficult to replace than a unique human being, right? So they end up distinguishing a case on a ground that actually makes no sense. Second, and this is another you see in lots of these cases, there's motivated reasoning designed to protect slavery and racial subjugation, right? Slavery is under attack, and many judges see their role as protecting the institution. So as a result, they might not have reached the best rule, they might have reached the rule that best protected the institution of slavery. Third, these cases have all been abrogated, at least in part, by the 13th Amendment, and I've never seen a court actually acknowledge that. And so in short, relying on these cases without addressing their underlying content risks making judicial opinions and legal briefs less persuasive. So even if you don't care about the stuff on my next slide, which I hope you all do, you should care as a lawyer that we're not getting these arguments right. But citing slavery without acknowledgement also risks creating dignitary harms, right? So one, you're disregarding the incredibly horrific language and reasoning that's taking place in these cases. You're also hiding the role that lawyers played in facilitating slavery, right? We lawyers like to pat ourselves on the back and say, we're the heroes of the civil rights movement, but also we're the villains, because we're the ones who enabled, our profession enabled people to be treated like property. And finally, we're, whether purposely, probably most likely inadvertently, perpetuating dehumanization of the law of slavery. The only way it makes sense to cite the Johnson v. Perry case today is if you continue to treat David as a piece of property. So in some way, that 1999 court is still treating him like property. So let me give you a few more examples to give you a sense of what this looks like. In 2015, Justice Thomas, writing dissent, relied on a case about the inheritance of enslaved people for the proposition, quote, that the judiciary is the tribunal appointed by the Constitution and the law for the ascertainment of private rights and the redress of private wrongs. So he's justifying judicial power by pointing to what we would likely think is one of the biggest abuses of it, right? Enforcing slavery. Here's another example. This one's from the Maryland Supreme Court. They similarly failed to acknowledge any issue relying on an 1862 case involving the sale of enslaved people as the lone source for justifying collateral estoppel. It's difficult for me to see how a case about the sale of humans serves to justify a legal rule on what justice requires and the public tranquility demands, right? So why is that the case you rely on for this? Here's another example. In 2012, the North Carolina Court of Appeals has to determine whether common law marriages exist in that state. And they say, no, we found an 1836 case which says that these don't exist. But the justification for why the common law marriage didn't exist is because enslaved people have the incapacity to enter into contracts, and to allow them to do so would curtail the rights and powers of masters. Again, doesn't seem like the best evidence for why common law marriage should not exist in North Carolina. Here's one, I've got to be fair to get my state too. As recently as 2015, the Michigan Court of Appeals relied on a quote from an 1846 Georgia case in which the litigant was attempting to, quote, recover the possession of 14 slaves. And they cited it for the center of and this is sort of at the center of an inheritance dispute about these 14 people. And it cited it for a case about theft of wine in storage, right? It's very, very different. Now, I think what's interesting about this case is it came from a treatise on torts, and the court cited that treatise. So it's not a direct quote, but it still, I think, brings up some of the same issues. Here's another example from my state. In 2001, the Court of Appeals was considering a challenge to a ballot referendum that required the court to interpret the Michigan Constitution's requirements that referendums not extend to acts making appropriations for state agencies. In this case, the Court of Appeals cited a Michigan Supreme Court case from 1967 for principles of constitutional interpretation, and in that block quote, cited to Prigg v. Pennsylvania for that. Now in Prigg, this is one of the most infamous Supreme Court cases of all time, the court struck down a Pennsylvania law that had provided procedural protections for Pennsylvania residents alleged to be fugitive slaves before they could be seized and carried out of the state. And Margaret Morgan, the person at the center of that case, was born in Maryland where she had lived on her enslaver's property but had practical, though not legal, freedom. And she eventually married Jerry Morgan, a free black man, moved to Pennsylvania, and then when her former, the person who had the legal right to her died, his wife inherited her and said, go get her and bring her back. And the court, the seizure took place at night when her husband was gone, and the slave catchers forcibly removed her and her children to Maryland. And so, and Justice Story in Prigg v. Pennsylvania said that was okay, that's constitutional, and that's what my state is relying on to interpret our Constitution. And just to give you a sense of what Justice Story said in that opinion, he said that by using these interpretive principles, he concluded that the Fugitive Slave Clause of the Constitution manifestly contemplates the existence of a positive, unqualified right on the part of an owner of the slave, which no state law or regulation can in any way qualify, regulate, control, or restrain. Now, maybe we think that that's a reasonable interpretation of the Constitution, but I'm still not sure that's what we want to be relying on when we're interpreting the Constitution in 2001. Here's an example from Ohio. In this case, in 92, an Ohio court cited a case in which someone was indicted for helping an alleged fugitive slave in support of a non-controversial doctrine of criminal procedure. Right? So here's an example, like, why use that case? It's not totally clear. This is another criminal procedure case from Ohio. The court, in dealing with a habeas challenge, also cited Prigg v. Pennsylvania, the infamous fugitive slave case I just mentioned. So one question you might be asking yourself is why lawyers continue to cite these cases, often for seemingly uncontroversial legal holdings, right? I mean, I think many of these cases would have come out the same way without citing the case involving enslaved people. In part, I think we can attribute this to the development of citation practices. So by making citation easier and more formulaic, West's innovations in legal publishing facilitated a turn to more citation-driven legal argumentation. Newer trends have contributed as well, whereas the West reporting system and case report editors once gave some sort of shape to this precedent, now you can just type into the Westlaw box, or maybe now into Westlaw Co-Counsel, and say, find me the first case about torts in my state, and you might just be able to click on the headnotes and never read the facts. And in some of these cases, it's only, very, very one or two sentences that say this involves enslaved people. So another way that we can think about how these cases have shaped the law is not just through direct citation, but also through the doctrinal networks these cases have created. So this next piece of my presentation is all based on a sample of cases that I traced the sort of doctrinal legacy of. So first, you'll see that slave cases are cited at basically the same rate as Southern cases in the same Southern courts at the same time, right? So this suggests that there hasn't been any sort of systematic avoidance of slave cases. But thinking about this direct citation is not going to be enough to show us how these cases have influenced, because we just generally don't cite cases from the 19th century that much. But if we use citation networks, we can begin to get a sense of what that looks like. So here you can see at the top is a case involving enslaved people. It's a Virginia case dealing with a husband's attempt to recover the right, actually just to one person named Asa on behalf of his wife. That's been cited only 3 times, right? The most recently in 1941. That's that second generation with the labels there. But on the bottom, you can see how many times those 3 cases have been cited. And the way I designed this diagram is that the darker the circle, the more recent the case. And you can see that there are some pretty dark circles at the bottom, because this 1856 case about Asa is actually pretty close to modern law. That's just one case. This is what it looks like if you do that for all 200 cases in my sample. So you can see, exponential growth from the slave cases in the top row, the case that cite those cases directly in the middle row, to a lot of really dark dots on the bottom row. So this transforms from 200 cases into something like 15,000. Here's what it looks like. Another way of visualizing it: green are the slave cases, red are the cases that cite those, blue are the cases that cite those, right? So the massive influence is possibly really huge. What's also interesting is, here I've mapped those cases onto where they were cited geographically, and you can see those cases are not just cited in the orange states, which were slave states, but in the green states, which were non-slave states, right? So these have influenced other cases as well. So I estimate that 18% of all American cases are within 2 steps of a slave case. So either cites it directly, or cites a case that cites a slave case. So that's like 1 million cases. So there's a lot of work that's going to be taken. We're going to require a lot of work to unpack how these cases have influenced the law. Now, obviously, not every one of these million cases you can say the outcome was different because it involved an enslaved person. But some of them certainly have. And let me give you a couple of examples. So in 1848, Maryland's highest court decided Townsend v. Townsend. In this case, the testator attempted to free enslaved people he owned and to bequeath his property to them because he thought that otherwise God would punish him. His brother and nephew, after his death, argued that this decision was delusional and therefore should be disregarded, and the court agreed. This is the first case to recognize what's come to be known as the insane delusion rule, which allows courts to strike down provisions of wills that they deem to be products of deranged beliefs. This insane delusion rule has since been adopted widely across the United States. And the Townsend court's adoption of this rule appears to have been influenced by its slave context. In the 1840s, many slaveholders and politicians understood manumission as a threat to the institution. And so from this perspective, the prospect of manumission threatened that racial hierarchy, and they were particularly afraid of the insurrectionary threat of free black people. So it seems likely the court decided to implement this rule because they wanted to avoid fulfilling Townsend's bequest. Now, in its modern form, lots of people have criticized this rule for encouraging challengers to a will to exploit a decedent's unpopular beliefs. I think understanding this context may help us provide sort of further more reasons to rethink that doctrine. Here's another example. I should also note that a case that cites Townsend v. Townsend is actually in the Duke Minier Trust and Estates book, which is by far the most popular one. Just not included in there, although I think it might be in the next edition. Here's another example. This one's not from the law of variance, but property law. So I'm sure you all know about the law of adverse possession, right? So the idea is that if someone abandons land and you openly and notoriously possess it for long enough, it's yours. Well, in the 19th century, this doctrine was extended to personal property. And every single one of those cases, the personal property was enslaved people. And the reason they extended it, I think, was to keep order in a slave society. One of the things that people are really worried about is what happens if there's someone who isn't controlled, like an enslaved person who is in control. And adverse possession allows an enslaved, to ensure that every enslaved person has an enslaver, essentially, right? And cases involving adverse possession of enslaved people have been influential. The Supreme Court of the U.S. Has been cited. Its cases involving this doctrine have been cited about 600 times. But the slave origins have been lost. Now all the cases deal with property like jewelry and art. So something like someone sells you a stolen piece of art, you have no idea. 50 years later, you resell it, and the person says, wait a second, that's my art. And the question is, does it belong to you or not? Now, modern commentators have noted how this doctrine doesn't make sense. How can you openly and notoriously possess jewelry or art? It's just hanging on your wall. How is a diligent owner supposed to know and prevent you from adversely possessing it? Well, it makes sense if you understand the reason the property this was originally extended to was enslaved people. Because possession of them is going to be open and notorious, right? You can even just ask them who controls you, right? And I think understanding the slave foundations here helps explain why we have this weird rule that doesn't make sense at all, because people have extended it without thinking about its original context. So in order for us to really grapple with the law, it's going to be very challenging, right? Because these cases have never been systematically accounted for. Their influence is going to be difficult to isolate. And I think it's particularly important to do this work requires kind of skills that lawyers don't have, right? To understand the context of slavery. But it's not just indirect doctrinal influence that these cases have also influenced. It's even statutory law. So in addition to teaching legal history and professional responsibility, I also teach secure transactions. And one of the most surprising aspects of teaching Article 9 is the right of secured creditors to be able to repossess collateral after default as long as they don't breach the peace. And when I teach this, my students are always struck with, like, how is that possibly allowed that people can just come take your stuff? The traditional justification is, according to scholars, treatises, and casebook writers, is that both functional and historic. Functional in that allowing repossession allows us to have cheaper loans. And historic, they say that this right of repossession is an ancient remedy dating back to the Dark Ages, as one has put it. And that when the UCC codified these rules, it merely codified centuries of repossession practice. In reality, if you go look back and look at these cases, the right of recaption cases that are supposedly the precursors to this right, recapture was only applicable in very rare circumstances. So basically, if someone had stolen your stuff and you knew where it was and you could seize it without breaching the peace, then you could take it back. But Blackston and other early treatise writers were very clear that the public peace was a superior consideration to any one man's private property. These were very strict, high standards. However, in the 19th century, slavery was, as I mentioned before, was an important economic enterprise and therefore was an important source for law related to personal property. And so it's at the center of two main changes. First, when courts expanded self-help repossession to allow for repossession of collateral after default, that was a massive expansion. And second, it helped lead to the alteration of the breach of peace standard. So when courts made the choice to extend the right of recapture to enslaved people, they accepted a higher level of violence than Blackston would have originally, because there's something inherently violent about seizing people. And we get to return to Prigg v. Pennsylvania again, this case, this famous fugitive slave case. This is the first case in the U.S. Supreme Court to talk about the right of recapture. And we still think of this case as a constitutional law case, but it's also in many ways a private law case. So when Justice Story wrote that the owner of the slave was clothed with entire authority to seize and recapture his slave whenever he can do it without any breach of the peace or illegal violence, he was applying that right of recapture, but he was also expanding it. Because by any reasonable breach of peace standard, this clearly was a breach of the peace. There were massive protests against illegal fugitive slave seizures, and Pennsylvania had passed a law making it illegal. Clearly, you cannot do this without breaching the peace. Now, this history, unfortunately, has mostly been obscured by the stories lawyers tell themselves to justify the power of this law. I think uncovering the hidden history of slavery undermines these justifications and provides essential context that we need to be thinking about. Now, I think it may be possible to justify the prevalence and violence of contemporary self-help repossession, but I don't think lawyers can do it in good faith without grappling with its more complicated legal past. You can't say this is a historic right, you have to say this is just the right thing to do. Now, because slavery is so deeply embedded in all the ways that I've talked about today, it's not going to be simple to address its legacy. But I think we have a special opportunity to work on this continuing process of emancipation. I think one of the first and most important things we can do is ensure that lawyers know how to think about history. Right? Interpreting these cases in their context requires understanding how slavery worked. And we recognize in some ways that being a lawyer or judge is a historical it requires historical skills, right? Precedent really is interpreting historical documents. But we're doing it without the context, the vital context that would help us understand those documents. So what can we do to help lawyers do this? Well, one thing I think we do is improve legal research tools. Right now, this is a case involving an enslaved person, but you have no way of knowing that. You can click on that head note, get the rule, and get out of there, right? So one of the things I suggest is that we could have a signal that says, hey, this case involves enslaved people, that might help encourage lawyers or judges to read this case a second time and decide, is this really what I want to be citing here? Now, making these changes will be difficult and face resistance, I think, particularly in the current political climate. But I will say that my team and I have had some successes. In 2021, the Blue Book added Rule 10.71D, which requires the parenthetical acknowledgement in law reviews when you're dealing with a case involving enslaved people. And this, we hope, will encourage those who cite these cases to grapple directly with their use. We've already seen some courts do this in their opinions, and there also are ways in which courts have distinguished cases and explain their place in history. So there are courts who are capable of doing this. I think there are ways, I think that's a necessary first step in doing this. But I also think we need to think broadly, think beyond citation. The solution to this is not just not citing these cases or acknowledging them. The solution is to acknowledge the role that lawyers have played in this system. And so one thing I think judges whose courts have cited these cases or decided these cases in the past could do is acknowledge them at the courthouse, right? It's a way to acknowledge the way that they've been complicit in the creation and continuing legacy of slavery. So drawing attention to these cases is part of the reason I started the Citing Slavery Project. You can visit our website at www.citingslavery.org. Once a case is uploaded to our database, the students verify, they search for these cases, they verify the case involves an enslaved person, they provide a short summary of the law, a jurisdiction, etc. And then we provide informational pages about each case. This is Johnson v. Perry. And not only do we provide information about the case itself, we also provide information about the courts that have cited that case. Now, that information is pulled using data from the Case Law Access Project. It's not perfect, so if you look at our website, you'll see we have lots of unverified cases, and that just means no human has said whether there's actually a citational link here. We also include in our database, and that's not part of the 14,000 number, just to be clear, the cases that cite those cases. So that way, people can actually read these cases and get a sense of how slavery has shaped American law. We also link to them on the Case Law Access Project, although they've sunsetted this provision, so we're working on finding a replacement right now. For now, it still works, but that will only be temporary. And one thing I will say, at a time when I think a lot of people are nervous about talking about this stuff or thinking about this stuff, I will say that we've received really useful feedback and engagement from a whole lot of groups. So both judges, scholars, law firms, people are willing to think through this and do this work. And so I just want to say that, if you feel like you're the only one who wants to do this, or just a few people, there are a lot of people in a profession who really do care and want to do this. I look forward to your questions and comments, but I also just wanted to say, please stay in touch. If you have any ideas for the project or anything, please reach out to me. So thank you very much.
Hello, Professor. I have a question and a comment, really. I'd like your thoughts on. The question is, when these Southern courts were first addressing issues involving slaves and property, did they rely on any corpus of prior case law, like Roman law, the way the Northern courts would rely on the Court of Exchequer, or did they come up with this all as first impression? And my second comment is, maybe I'm a bit of a dinosaur, but it seems to me that in the cases I've been involved in, all the written opinions of the court were some amalgamation of the prior briefing. Nothing original there. So the attorneys must be citing these cases, and I think I can say, honestly, that I've never cited a case that I didn't read. And I can't imagine why I would be citing a case from 1820 when there's going to be a more direct case on point that's modern, like the tire shredding case. That's the standard way to assess the diminution of a value of an automobile. I have no idea why I would be citing a case from 1820. So I get quite a bit there. But thank you very much.
Yeah, thank you. Those are wonderful questions. So there are instances in which the treatises especially think through other laws of slavery, like Roman law, like you're saying. But in general, they really try to wedge these cases into, like, the bulk of these cases, enslaved people are just regular property, right? There are a few of these edge cases where how do we deal with property that's also a person, but mostly it's just how do we deal with property, right? For the amalgamation of briefing, I was surprised when I was doing this research. I found that there's an article that suggests that only 50% of the cites in judicial briefs in the sample they used were introduced by one of the parties. So there is a huge element in which some judges are doing their own research. And I had the same question, like, why would you ever cite a case you're not reading? I think it's hard to understand, but I think a lot of lawyers are just not as diligent as you were, and I think a lot of lawyers are just copying and pasting citations from treatises, from prior opinions, and you could see this sometimes. For instance, there's this case about an enslaved person that isn't cited until, I think it's in Florida, until like 2010. And then right after that, cited two more judicial opinions. So I think people are cribbing from each other, and whether it's the lawyers cribbing from the opinions or the judges cribbing from each other or not. And why cite these cases? Also a really puzzling question. I think part of it is it's a way to demonstrate legal learning. It's a way to demonstrate look, we found the first case that first articulated these principles. And that's some way of showing off, of making these, identifying this judge as someone who knows what they're doing. I mean, I think you probably would want to read the cases if you're doing that, but I think that's part of it. I think also, if you just pop this into Westlaw, and the first case that mentions this doctrine in your state comes up, why not cite that? That shows you that this doctrine has lasted forever, and I think that's part of what's happening here. But certainly this doesn't look like the reasoning by analogy that we all learned in legal writing class, right? It looks more like somebody looking for a good quote, right? And other people have remarked on this. They've referred to it as the statutorification or textualization of legal citation, whereas in the past, we sort of used cases as a way to reason with the common law to figure out what the rule is, and now a lot of times what people are looking for is what's the controlling precedent, and can I have a good quote from that I can then use and apply. And I think it doesn't say good things about the legal reasoning of these judges and lawyers.
So I don't think a huge amount of my scholarship about personal property. I think more about intellectual property. But one of the things that we've seen in public discourse more recently than before, right? This seems like a sort of growing, perhaps political divide on the extent to which the value of personal property is inviolate, right? One's personal property shall not and must not be interfered with as a principle of basic sort of dignity. And I think there's some political divide on that. Watching this, particularly the first portion of this discussion, made me really wonder, are there scholars out there, and are you one of them, in the personal property area talking about how maybe our concept of the inviolability of personal property started from a really bad place? And maybe it's worth rethinking some of the very core concepts about the extent to which personal property might better be shared or more viable.
Yeah, that's really interesting. I hadn't thought of it in that way before, but I think one of the things you learn by studying these cases is what happens when legal decision making goes bad, right? And what are some problems with it? I think that's one of the ways that we could think about these cases is the problems with these inviolable rights. But what's also interesting is these courts are also willing to sacrifice those inviolable rights when they think it might threaten slavery, right? So the Townsend v. Townsend case is a perfect example. Freedom of disposition is the core principle until it's not, because we want to prevent people from, giving property to their slaves. And it's actually the same thing is happening not just in the law, the common law, but also statutorily at the same times. And I think that you could also sort of use the other way too. Well, we were willing to, if you're trying to argue against this strong and viability of personal property, you could say, well, we were willing to compromise that to protect slavery. So maybe we should be willing to compromise that for other purposes as well. I mean, so it's interesting, kind of go both ways.
So I've got two thoughts that I'd like to share. One is, in the midst of your discussion, you sort of noted what I would call, the incompleteness of Reconstruction, right? The sort of problem that slavery wasn't abolished so much as it simply stopped, at least explicitly. And then it also got reinvented in certain ways. And of course, that couples with the legal legacy, excuse me, that you're pointing out. And I think that just my observation is that we as lawyers need to understand that about the US system, especially in relation to private law. And I like how this project sort of brings that out. So I'm going to jump from history to the future because I happen to be thinking a little bit about advanced technology and AI, and your references to legal research made me think about how research models are becoming more and more dependent on generative AI, and it makes me think, and I don't know if you worry about this or not, but whether some of this sort of amoral intuition sort of sneaks in, given how we're jumping beyond just simply finding it in the books and finding the right language and cutting and pasting to, hey, the computer can find it for me. And now we're hitting the era of, well, the brief can just be written by the computer and I can just go and edit it, right? So it would seem to accelerate this problem that you're pointing out. But that's just my thought. I'd love to hear yours.
Yeah. So both interesting questions. The first, so the incompleteness of abolition is something that Black studies scholars have done a really great job of thinking about. So Ronaldo Walcott has this concept of the long process of emancipation. And I feel like I see this project as part of that project. And I think, it's not, it really is the incompleteness of abolition, which is exactly the opposite of what, like, politically people are moving toward now, right? Saying the colorblindness and pretending that it was a complete and successful project. And I think it's also important to recognize, as you pointed out, private law. There aren't a ton of people thinking about race in the history of private law. There's a few people, Dylan Penningroth, K-Sue Park, Brittany Farr, but there's just a handful of us who are thinking about these issues, and I think it's really, really important to be thinking about them more broadly. I think not just historians, but also people who are studying work in the present. I think it's really important to think about, there's a bigger group of there, but it's still not as big as I think it ought to be. Now, as far as the second question, a student and I presented this paper this summer where our argument was, we're all worried about the ethical implications of AI, but we still haven't grappled with the ethical implications of the legal research platforms we do have, right? And to your point, computer scientists have this saying, garbage in, garbage out, right? And so if these opinions aren't distinguishing slave cases, then AI is not going to do it, right? To your point, and I think I'm not sure, if already the legal research tools are encouraging lawyers not to read their cases, as you were saying, well, I mean, AI is not going to help that, right? And I don't know, I don't know what to do with that, right? I think my hope is that maybe people thinking about the ethics of legal research and paying attention to legal research will draw attention to this kind of thing. I think there are very few people who are thinking about the nuts and bolts of this besides legal writing professors and law librarians. I think more doctrinal professors should be thinking, and more practicing lawyers should be thinking about the way that research is affecting what they're doing, because it's really an important influence on the outcomes we reach.
So a couple of questions. First off, I mean, you've shown a willingness to contact the people who draft the Blue Book. Have you thought about reaching out to Lexis and Westlaw and asking them to, flag these cases, render them radioactive, perhaps, or at least so that people take a look? In addition to that, I do have the question of whether or not that might not be a completely good thing. I'm wondering if, based on your research, whether or not you've tried to code the cases as to whether or not they have negative outcomes or positive outcomes. Because I have to imagine somewhere in that 14,000 case population, there are cases that talk about the vindication of human rights, that vindicate the rights of people, of human beings to deserve to have their rights vindicated. And I do worry, that in some instances, if you start putting these labels on these cases, that people no longer will think about them in deep, meaningful ways. They'll just say, well, I'm a busy person, so I'm not even going to really meaningfully consider that case at all.
Yeah, that's great. Both good questions. So I have reached out to Westlaw. I gave a presentation at the Hennepin County Law Library, which is in Minneapolis. This is where a lot of Westlaw people work. We talked about it. And then they sort of dropped the ball, and I think particularly in this climate, I'm waiting to pick it up, I think, to a later moment. I think these databases are very small c conservative, right? And so there was actually a big push to a really long time to get the infamous Dred Scott case to be marked as overruled. Like, there was actually a campaign by law librarians to put it there because there wasn't an explicit enough acknowledgement that the case had been overruled by an amendment, by the 14th Amendment. So I think I'm still working on it. I think it's a long-term project, and in part I want to be able to give them a very good, clear set of cases so that they can, if they want to do the work, I can just say, here's my list. As far as the second, but I do worry, as you pointed out, about the negative outcomes that people see this as a slave case and are like, yeah, I'm too busy to read this. I don't want to, engage with it. That said, I wonder whether people are doing that now. I think in some ways you might say that a signal might increase engagement, even if what it means is someone sees that case and says it's radioactive, I don't want to touch it. They might say, wow, there are a lot of these radioactive cases that I don't want to touch in my law. Now, the challenge is, and the reason I don't say just don't cite these cases is, yeah, they do establish good principles sometimes. There's a lot of freedom suits too. Now, as a percentage of the cases we've collected, relatively small, but there's a lot of them. And as other historians have pointed out, sometimes a court's devotion to legal technicality and legalism led to the result of surprising results where African Americans' rights were vindicated, including against white people in litigation. Now, that was rarer the kind of earlier ago, but it was a real phenomenon. And so one of the things, and I really recommend Dylan Penningroth's book, Before the Movement, which talks about the ways in which African Americans used civil law to their benefit, to resolve disputes, business disputes, to form companies, that kind of thing. And so the law, there's more complicated, the legal relationship between race and law is more complicated than just subjugation, right? It's a tool of empowerment too. And I think, to your point, these are all things we should be talking about, but we should be talking about them, right? And I think those conversations don't really seem to be happening that much, in part because our legalistic standards, the way we approach both writing opinions. Dylan, in order to find how many of these cases involve black people, had to go back to the district court records because all the appellate cases, they've been erased. And he's found that there's actually some really classic cases involving black litigants. We just don't know. The famous case where there's a woman who prevents someone else, from another woman, from killing a man with an axe and is in the process injured. Involves everyone in the case is black, and and the reason they had to rely on the protection of this woman is because they called the cops and the cops didn't show up, right? They weren't going to help them. So, I think it's a much more complicated relationship, and I just would hope that we can still have these conversations. And I hope that the goal of my project is not only to say the importance of these conversations, but also to say that these conversations will make us better lawyers if we're really thinking about the context of these cases. So even if you don't care about the humanity of black people, you should at least care whether you're a good lawyer or not. I don't think there's which is why I think the way forward is more than just we cite these cases, we don't cite these cases, we acknowledge these cases. It has to be a broader reckoning of the legal profession that I think people were up for a while ago. I'm not sure there's up for now, but I think it's something it's still important. We should keep trying to do.
Can I just do a shameless plug really fast and say, since you've mentioned him now a few times and he's certainly present in your scholarship, Dylan Penningroth will be here on September 11th as our Battisti lecturer at the start of the fall semester next year. And he'll also be at the City Club of Cleveland, thank you, at the City Club of Cleveland as a part of their Friday Forum series the next day. So, but thank you so much to Justin and Samard for his presentation today.
And thanks to the Social Justice Law Institute for helping organize this, and to Eric Chafee for doing a lot of legwork.
Absolutely. Thank you.
Thank you all.
Thank you.